Now joining us is Mark Avera. Hi, Mark. Mark, let's talk about wills. It's something that's easy to put off, but they're very important, aren't they?
Well, our firm in the past 5 years has done more and more litigation involving disputes over wills, whether undue influence was used to persuade somebody to change their will in favor of another family member or a caretaker. The first thing that I would tell folks is if you don't have a will, a state statute is going to decide how your assets are allocated among your spouse and your children and your heirs.
So it would not automatically go to your spouse?
A percentage would, but if you don't want that percentage to go to your spouse, you want more to go to your children or a greater share to go to your spouse, you have to have a will. And a lot of people use forms that they download or they acquire to do their wills, and those forms may or may not comply with Florida law. Florida statute has in place the requirements that you have to have regarding witnesses and form of the will to ensure that it is a valid will. And if you don't have that, the will is invalid and everything reverts back to the statute. So I would encourage folks to have a lawyer involved and to help them with the preparation of that will. We don't do wills at our firm. We're always happy to help people find somebody qualified to do that. And that's where we run into problems with wills in the litigation is when folks take a family member or a caretaker, takes the person that they're caring for and has the will changed to something other than what it was originally and what other family members may assume it to be. They don't realize the will has been changed until after the family member passes on and the will is then probated. If you're going to change your will, and if you have any suspicion at all that's going to cause any problems with the family members, videotape what you're doing. Speak to your heirs on videotape. There are companies that do that now. They'll come and videotape you talking to your heirs. This is what I'm changing. This is why I'm changing it, as proof that that person has the capacity, the mental capacity, to make that change and the reasons why they want to do that. That would save a lot of the problems that folks go through now with lawyers and litigation and would avoid all of that.
So people think they've done everything right when they get a will off of the internet, but later they discover, or their family does, that they've done something very wrong.
Well, what if the form says that this form complies with Florida law and they get it off the internet? Well, how do you know? Just because it says that it does comply, does it really? Ask a lawyer who does wills and specializes in doing wills, perhaps even somebody that's board certified, to take a look at the will to make sure that it complies with Florida law before you declare this is my will and you file it away. Make absolutely sure it complies with Florida law, because it may later be deemed to not comport with Florida law, in which case it reverts back to the statute and state statute is going to decide how the assets are allocated.
So tell me what happens when a dispute does arise.
How it often comes up is that at some point before the decedent's passing, the decedent is the person who does the will, somebody, it can be a friend, a caretaker, another family member, persuades them or asks them to change the will. Or they may decide on their own to change the will. Sometimes when the litigation is ensuing, we're trying to find out why the person made the change. If somebody makes a change in their will, there needs to be a determination that they have the mental capacity to make that change. For example, we're involved in a case right now where a lady has a will in place. She has several adult children, and she is evaluated by a psychologist and is found to have some deficits. That raises questions about whether she had the capacity to make the change that she made after the medical provider found those deficits to be in place. That's why a video would be important in those kinds of circumstances, where you videotape the family member or person wants to change the will and decides, I want everybody to know why I'm making this change. So they make a videotape talking about the changes that are being made, when they're being made, and why they're being made. You have evidence in that video about whether a person has capacity or not. Are they able to speak clearly? Do they have any problems explaining what they're doing and why they're doing it? That's evidence in a case about whether a person has mental capacity or not to make a change in a will.
So when there is a dispute, is it decided by a jury trial?
No, it's before a judge. A judge determines that, and the burden is on the party asserting undue influence. They have to demonstrate that the decedent had insufficient capacity, testamentary capacity to make the change in the will, that undue influence was exerted upon the decedent by whomever is alleged to have been acting in such a manner. But that's decided by the judge after the judge hears evidence from both sides on that.
So you can't be too careful. You should have a will and a videotape.
You should have the will, and the videotape just makes absolutely sure there's not going to be a dispute after you're gone about whether your will was done when you had capacity to do it, and particularly if you make any changes later on and not everybody knows about the changes. I think you should absolutely do a video in those circumstances.
Thank you, Mark.
You're welcome.